Welcome to Notable Approvals. I am attorney Amanda Schaefer. 2 days in a row, got off to a good start this week. I want to talk about another exciting case today. Before I do, make sure to like us, follow us, Facebook, YouTube, Instagram, wherever you are watching, so you don't miss any more of our lives. And if you find this to be helpful or know someone who may, please hit that share button to share this hopefully helpful and useful information. So today I just got back from court. It looks like my phone is slightly in the way there. Okay. Or either way. And got back from family court. And had a family offense petition against my client dismissed. What is a family offense petition? Family offense petition is something that if you are, the best way to describe it, there's two parts. You need to have a certain type of relationship with the person you're filing it against, and they have to have committed one of a certain list of offenses, one or more of those offenses. Now, these offenses are in the law. There's the most common ones are disorderly conduct, harassment, assault, those types of things. The requisite relationship is it has to be either someone you're related to by blood or someone that you have had an intimate relationship with or lived with. It can't be just a friend or a coworker. It has to be someone a little bit more than that. So if you have a family member or you're a partner that you've had an issue with, and either you don't want to go to the police, for everyone has their reason why they don't, or you don't think it's as serious enough to go to the police, but you want some type of protection, you can go to family court, file a petition, and then whoever represents the person filing the petitioner, or the person who files the petition, known as the petitioner, is essentially like the prosecutor, and the other side's like the defense, but it's not a criminal court. These matters could get referred to criminal court. I've never had one. I've never seen one get referred, but they definitely do and can, usually when they're more serious. But what it is for is really to get you, or what a lot of people know as a restraining order. In New York, we call it an order of protection, which is either going to be a refrain from. So basically, don't commit crimes against this person, don't annoy them, or a full stay away, or there can be kind of in between. It could be crafted for your particular needs. So a full stay away, I know a lot of people think that means I have to stay 100 yards from the next person, 100 yards from this person. It's not necessarily yardage. It usually is a stay away from home, school, employment, and then it can also have other conditions like no third-party contact, don't talk to this, contact this person directly, etc. It is very common when these applications are filed in family court, when the first day they get filed, the other side, the person you're filing it against, doesn't know because you haven't served them yet. So you see the judge without the other party even knowing anything's happening. And it's very common. In fact, I would say, I don't want to put a number on it because I have no idea, but every single time I've filed one, every single one I've heard of, except for a handful that were filed pro se or without an attorney, the judge will give what we call an ex parte order of protection. That means the other party wasn't there to defend themselves or anything. It's actually very similar to what would happen in a criminal court. If someone was arrested, on release, they would get an order of protection against them in the victim's favor, and both parties aren't usually present at the arraignment. So, and they do have a chance to defend themselves, but it's I don't even know if it's mandatory in domestic violence cases, but it definitely is pretty much standard when it comes to these types of crimes against other people. So family court can be a nice alternative for someone who's doesn't want to send anybody to jail, or who kind of just has said to, let's say, an ex-boyfriend or girlfriend, I want to be left alone. I'm over, we're over, move on. And they just can't, they just keep it, texting you, emailing you, calling you, not getting the hint, not taking the direct hint, and filing this can get them to be like, oh, okay, they're serious, they're done with me. So, we do a lot of these, and I recommend them for people, depending on your situation. It is definitely a good option. When there's physical violence, I usually do recommend going to the police, but again, everything's case by case. So in this case, the client is in his 20s. He's a student, and he was living at home still with his parents. And even though he did have a separate part of the house, separate kitchen, separate bathroom, separate room, they did share an entrance, so they weren't completely separate. But he did have his own space. And him and his family have had what I can only describe as a tumultuous history. They've called the police. He has siblings as well. There's been complaints filed with the police on both sides where no one's been arrested. The sister 2 years ago filed a family offense petition against him that I represented the same client for, and that basically the sister didn't even show up the first day and it got dismissed. So there's been a lot going on with this family, and it is common. I mean, families fight. It's sad when families fight, and to the extent where they have to turn to litigation to help resolve their problems. But again, that is what family court is for. So it appeared that even though his sister wasn't involved this time around, it appeared she may have been influencing the parents. When mom filed this petition back in October, my client moved out of the house. Even though it was a refrain from temporary order protection, the judge knew he lived there, so a full stay away would have really been impossible unless they were forcing him to move out. But he was in school full time. He couldn't work because of that, and he's a very hard worker. Without revealing more, I will say he is impressive in what he's been able to accomplish in his life so far. But unfortunately, he's dealing with a lot of issues at home. So he did move out because he was really afraid that, his family all they had to do was pick up the phone, call the cops, and say, he's annoying us, and he could have gotten arrested. That's really where the power of these orders of protection come into play. Even if it's not a no contact order where you and you're still allowed to talk to one another, it's still a threat, because the police will, like I said, they had called the police before and the police didn't do anything. But when you have that temporary order of protection, not even a final, and you call the police, then they almost always arrest, unless they flat out don't believe you or something. So it's a very big risk to have that hanging over your head. And I do understand why this client did not want to continue living there. And unfortunately, it was hard, but he was able to find another place. So it seemed that after he left, his sister moved back to the family home. And so there was some indication that the sister may have pushed mom to do this. Honestly, it doesn't matter. She wasn't at court. She wasn't involved. She's an adult too, and she could have refiled if there was an issue with her and him. So it really wasn't about her. But basically, like I said, it wasn't about her, but she actually was mentioned in the petition. So that's why I'm saying when you're an adult, you gotta file your own. It doesn't matter. So when I read the petition, I realized that the petitioner failed to state a claim. What that means is that whenever you file any type of petition, motion, lawsuit, whatever it is in court, you have to allege facts that make a claim under the law where the court can grant you some form of relief. Otherwise, there's no reason to be in court. When it comes to a family offense petition, you have to set out facts that allege one of those enumerated family offenses, whether it's disorderly conduct, harassment, menacing, stalking, assault, sexual misconduct, intimate touching, grand larceny, destruction of property, any attempt to do any of those. I covered most of them, actually. I didn't cover all of them. There's a few more there. But aggravated harassment, you want to throw another one in there. You have to lay out the facts. So what does that mean? So I'll give you an example. In this case, mom, and this also happens a lot when someone files it without an attorney, she listed every single one of those family offenses in the petition. Now, when you read the fact patterns, I just rattled off a bunch of the family offenses that could have been listed. You can easily see from the fact pattern that some of these just completely did not exist. She didn't say he stole anything, for example. So grand larceny, cross off. So when you narrowed it down, there were only a few that it could even plausibly relate to, the offenses. So we'll look at some of the most common ones. So disorderly conduct is one of them. And you have to show, so let me tell you the definition first. And there are 6 subsections of disorderly conduct. I'm going to talk about the 2 that applied in this case, or somewhat applied in this case, but also they're also the 2 most common in these types of cases. So with intent to cause public inconvenience, that's key, annoyance or alarm, or recklessly creating a risk thereof, a person engages in fighting or in violent, tumultuous, or threatening behavior. That could be it. Or creates a hazardous or physically offensive condition by any act which serves no legitimate purpose. Now, I emphasize public inconvenience because that's important. Disorderly conduct is generally speaking something that happens out in public. When it comes to the criminal law, it has to have occurred in public. When it comes to family law, the second department, appellate department in New York, the second appellate division in New York, has said that when in family court, you can have disorderly conduct if you're in a private space. I put the emphasis on the wrong if whatever happened in your private space, you intended to cause public inconvenience. So, for example, let's say you and your mom get in a fight at home, and you live in a multi-family house, or you live in an apartment building, and your neighbors call the cops on you because you're so loud. Well, being that loud, you should know that you're recklessly creating a risk that you're going to annoy other people, or that they might hear you fighting, and they call the cops. That's public inconvenience. That's where the public part of it comes in. If you have a quiet fight and nobody hears you, well, even if you are engaging in this fighting or violent behavior, it doesn't make up a family offense. Another common one is harassment. And for harassment, it's when somebody engages in a repeated, there's different forms of harassment, but the most common one is when someone engages in a repeated course of action with the intent to annoy, harass, alarm. And the key with this is it serves no legitimate purpose. So you see this a lot, for example, with custody disputes. Mom may have said to dad, or dad may have said to mom, I've had enough of you. Our relationship's over. I don't want to talk to you. Gets an order of protection. And the mom says, texts dad about the child, or not gets an order of protection. Like, once the person tells you to leave me alone, you should leave them alone. And then mom doesn't leave the dad alone and texts about the child, dad files family offense petition. Well, it's a legitimate purpose if you have a shared child to communicate about your child. And in fact, when it comes to these orders of protection, in those cases, a lot of times there's what we call a carve-out provision that says the only exception is you're allowed to have contact about the child. But again, you have to make sure there are facts that make up all these things. And that's where this petition really failed. So there was only, I think, 3 family offenses that this could have even reasonably been. And mom, in her petition, really just wrote conclusions. She said things like, I live in fear because of my son's abuse of me. He doesn't let people see me or visit me. He verbally assaults me. He wishes me ill. Those are conclusions. I live in fear because this person abuses me. This person abuses me. Well, you're getting to the conclusion. You have to say why. So what would be the difference? I live in fear of my son daily because he has threatened to hit me and has raised his hand before. And I've seen, he gets very angry and he's punched the wall near me. Or he yells at the top of his lungs and his face gets so red that I know he's any minute now he can just snap and, hit me. You have to describe the behavior that's gone on in as much detail as possible. You can't just say, I'm scared of him. Now, wishing somebody ill or wishing somebody was dead is not very nice, but it's not a family offense. And before I file a motion to dismiss, one important thing that I do is I have to decide if I should file one, because obviously it takes some money to file one, but we only do it if it's worth it. So the standard is that you have to assume every fact is true for a motion to dismiss. You can't, even though I don't believe what was in the petition was true, it didn't matter what I believed. It didn't matter if it was true. What mattered is when the judge decides if there's any family offense alleged, if the facts make up a family offense, then filing motion to dismiss is pointless. So you assume every fact is true. And even if you assume every fact is true, you can't reasonably say this fits into what they call all the elements of the offense. And that's the same in criminal law, or really with law in general. If you're trying to prove a claim, there are certain things you have to prove. And if you don't, so when I gave this example of disorderly conduct, if you don't say that it caused public inconvenience and how it caused public inconvenience, even if everything else is there for disorderly conduct, you don't have disorderly conduct. If you don't say that it annoyed you or alarmed you or recklessly created a risk of alarming you, then you don't have disorderly conduct and it should be dismissed. So I had to actually, because every family offense was listed, even though the fact pattern was a paragraph that looked this big, sometimes you get, pages and pages and pages. I had to read the definition of every criminal law that it referred to and make sure that the facts couldn't constitute any of those offenses. And after my analysis, I found that they didn't. And I said to my client, let's do this. Let's file this motion to dismiss. So before we got to the motion to dismiss, at the first appearance in court, I spoke to the opposing counsel and I said to her, and she was an appointed counsel, and I said, there's no family offense here. This should be just dismissed. I'm going to file to dismiss it. And she kind of acknowledged it. And she said, I tried to get my clients to withdraw it, but, she's afraid. She didn't want to, blah, blah, blah. And I'm like, okay, they're going to force me to file a motion. As an attorney, there are certain decisions that you have to make as an attorney, and there are certain decisions that you have to let your clients make. And when it comes to a withdrawal of a petition, that is your client's decision. If you don't agree with them, in her case, she was an appointed attorney. She could have asked to be relieved, but it's much harder. But you could withdraw your representation. But in general, if you continue on with it, if you have to, you do. And you represent the person the best of your ability, unless something is completely without merit. I mean, this wasn't completely, I've seen a lot worse. We'll put it that way. This had no merit, but, there's definitely a lot of animosity between the families. And, this was a person who was not a lawyer filing it. The lawyer appointed could have amended it, but there wasn't really much to amend. So at the first appearance, I told, we had this discussion with the judge, and I said, look, my client's moved. He was moved out. He hasn't moved his stuff out yet because he was scared to go back, but he's moved out. And, this mom doesn't leave the home, and they're in completely different boroughs now. And like far away, not like probably like an hour and a half to get there. And he has no desire to go back. And the judge asked if they would withdraw it, and they said no. So I said, okay, well, we're going to file a motion to dismiss. So the judge gave us filing deadlines. I had a deadline to file my motion, and opposition had a date, and then I could have replied if I wanted to. I filed our motion to dismiss, I think, a little early, actually, basically saying what I'm saying here, with a little bit more detail, of course. And the opposing party never filed an opposition. And I said to my client, well, that's good news. In all likelihood, the judge will dismiss it because there's no opposition. So we got to court today, and just to remind you, I said at the beginning, there was a temporary order of protection that existed that refrained from every time you go to court, it gets renewed. So this is still kind of hanging over my client, this order of protection. We get to court today, and I spoke to the opposing counsel, and she said, she asked if my client really moved out, and I said, yeah. We actually was going to ask you if we can arrange for him to pick up his stuff because he's afraid to go without either police presence or a third party. And she's like, yeah, we can definitely do that. And she goes, all right, let me talk to them. I think because she's like, I read you after you filed your motion, I told my clients there was no point to respond to it, but they didn't want to withdraw it. I think now that they have confirmation he's moved out, they'll agree to withdraw it. I said, okay. We went into courtroom, and that she told the judge they were withdrawing it. And I say, that's great. We're all for that. And I had to withdraw if we're getting real technical with legal stuff, I had to end up withdrawing my motion to dismiss because there was nothing. They withdrew their petition. There was nothing to dismiss anymore. But it did appear the judge would have granted it had they not withdrawn it. So I was happy that my hard work in filing the motion to dismiss, because they're never easy to file. And they're always a risk because of the fact that someone could amend it, she could refile it. I could, the facts, like I said, you assume they're true. And the way the judge has to look at it is has to look at it in these facts in every angle. Is there any possible way there could be a family offense? So I don't file these too often, but when I do, we win. And we win because I will only file them if after doing research and after making sure it's a good claim to file a motion to dismiss for. So by withdrawing their motion, they also vacated the judge had to vacate the temporary order of protection, and the case is over. So my client was incredibly happy, of course. He didn't have the weight of this temporary order sitting on him. We are gonna have him, he's getting a friend to come with him to the house. We're gonna tell them so they could know he's coming and not be there, or just, stay in their own space to try to prevent any conflict that can arise. And then he will be hopefully not have to deal with this again. In my opinion, this type of case was more of a landlord-tenant case because it seemed like mom and dad wanted adult son to move out, and adult son didn't have money to move out, and they effectively, you could say it was a constructive eviction, but that's effectively what happened. Constructive eviction is when the landlord makes it so, or whoever you're living with makes it so unlivable, so uninhabitable that you have to leave. So examples are cutting off your gas or water for days on end, making it so that you don't want to live there anymore. And you basically evict yourself. So it was kind of like that. But like I said, it is sad that this family has had to go through this, that haven't been able to work out their issues without the help of lawyers and courts, even though in both instances with this family, it ended in a similar fashion. I won and my client was happy, but and it wasn't too much. This wasn't one, either one didn't drag on for forever like some of these cases do. But of course, it's never ideal to have to be in any type of litigation. However, like I said, at the very least, if you are in a situation where you do need protection and don't want to involve the cops, it does provide you that alternative option. So that is all today for notable approvals. Hopefully I'll be coming at you with some more exciting cases later this week or next week. I always try to do them as they come in. But as I've said many times, I'm looking at a list right now that dates back like 2 years for old cases that I haven't been able to talk about, but they're just as good, and I will definitely get to them as soon as I can. But I'm always excited when I come back from court, so I try to do them right away. And we got a few comments before I go. I like them both. Thank you, Lambert. I appreciate you watching, and I appreciate you, my man. So that is all for now. Don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. If you found this helpful, please hit that share button so that other people can see it as well. So that is all for now. Thanks for watching and have a great day.